Hey everybody, thanks for joining today. We're not getting started quite yet, but I wanted to open it up so people could play with their mics, play with their settings, make sure they got it where they want it. We are going to go ahead and open our first poll of the day. You can see that on the right hand of your screen. That poll is just a basic question about deeds. Where is your basic knowledge standpoint right now? Like I said, we'll do introductions in just a minute and we'll get going. For right now, we're just letting people get in and ask questions if they have them about this app and this platform and how it works. Lindsay, do you know how to share a poll? I don't know where it
Yeah.
is.
Oh yeah, let me put it up. I just noticed your other one.
Oh yeah, we're gonna end on that one.
All right, poll should be up. Ooh, it's always interesting to see as the answers come in. Whoever put that they know all the different types, I feel like we should just invite them up and they can do the class with us. Oh, no. All right, so Jeffrey will be back momentarily. I'm going to hold it down myself for a few minutes until he comes back up. It looks like his computer decided to crash right in the middle of our class, which, if that's not something that shows you what life is like during the pandemic, then I don't know what is. I, for those who don't know, am Lindsay. I'm Jeffrey's realtor liaison. So I don't know enough about deeds myself to do the class for you, but hopefully he'll be back in a second. And I'm just going to go over a couple of the basics while we're waiting for him to come back. This is the second class in our, thank you, Sonia. This is the second class in our new Realtor class series. And so the last one, if some of you didn't catch it, was on title and understanding title and what happens with that, how we can avoid title issues, what happens when they come up. If any of you missed that and you want to catch it, I will post a link to our blog. I should have had that preloaded, but I do not. So, one moment. All right. All right, so if you are on a phone, do not click that link right now. Just try to get in there real quick. The link will stay up throughout the class. You can click it at the bottom of the screen. If you're on a computer, you're totally fine. It will open in a different tab and you can keep it and look at it later. If you're on your phone, it will take you out of the class and you won't be able to see or hear us anymore. So if you're on your phone, just wait until the end of the class, or you can just visit our website, which is momgridmiddleton.com, and you can go to the blog page, and there is a section for our realtor classes that you can find later. So there will be a couple links and a couple handouts and that kind of thing that we share throughout the class. Same goes for the whole thing. If you're on your phone, maybe wait until the end of the class to click it, just so that you don't get kicked out and you won't be able to come back in. If any of you have a question throughout the class, there is a chat available. And if you're on your phone, I believe you have to swipe. But if you're on your computer, you should see it on the right-hand side over there. And you can just type your questions in the chat throughout the class. Jeffrey should be able to do about 20 or 30 minutes of just a talk on deeds. And after he's finished with that, you'll have an opportunity to do like a Q&A with him. And so he'll pull your questions up on the screen and he'll answer them live. If any of you would like to be pulled up on video, then we can definitely do that. You just have to let us know in the chat and we would be happy to pull you up there and you can ask him live. Otherwise, feel free to just type your questions in the chat. And then at the end of the class, we will post a registration link for our next class, which is on Tuesday, April 6th, and it is a behind the scenes with a lender. And so you will learn all about the process, the loan process from the lender side, things that can go wrong, how to hopefully not delay a closing due to loan issues. And we will be featuring Melissa Butler from North Alabama Mortgage. So mark that date on your calendar. That's April 6th at 10 a.m. And every first Tuesday of the month, we'll have another class. Jeffrey, are you back?
I am. Sorry about that, everybody.
Yay. I almost did the class on my own.
No
just
doubt.
So you know.
Technology's hard. Gosh, like I said, too many programs running at once.
I feel like everyone has seen this happen at least once in the last year now. So
back. All right, so you've done introductions and we're all good to go?
I believe so, yes.
All right. I see our polls up. We only have 8 people have answered so far, and we got 20 in the class. So feel free to pop over those polls and answer them as we go through. We're going to go ahead and jump in because we have a lot to get through, and I want to have a lot of time for questions because, again, the whole point of this is a roundtable discussion so that we can all talk about things, and it's not just me going one way here. We're going to start today so now that I've opened the slides here, there's going to be a bar above the slide that you can raise and lower to make the picture bigger or smaller. So feel free to play with that and make that fit your screen how you want it. My general disclaimer here is going to be that we're talking about complex legal issues here. I'm trying to make it digestible in 15 minutes. So it's not going to be a really in-depth view. It's going to be a very surface level view. This isn't legal advice. This is supposed to be just a conversation, and I'm going to lay out some general concepts and then we can talk about it. Let's see here. We're going to start today. Obviously, Bear is going to be featured in all of my slides here today. You'll just have to put up with it. I think it's fun and exciting, makes it more interesting. So let me get to my notes here since I crashed. Got to reopen everything. Give me 1 second. All right, there we go. So understanding deeds is our topic today. Before we get going, I just want to really open up what we're doing here as a basic level. On a basic level, we're talking about real property, not personal property. Let's not confuse the two. Real property is land and all things fixed to that land. We can get into the definition of fixed at another time. That's not what we're here for today. I just want to lay out that a deed is only about real property. We are also talking about the transfer of property and what happens in that transfer. I will refer to that as a conveyance. That's what we're talking about, is the conveyance of property from one person to another. Generally, there are different types of deeds. You can read that there, and we'll get more into those as we go. As you can see, this is my first real cute picture of Bear, which we'll see plenty more as we go through it. As an intro to property ownership, my general process here would be to ask you guys, what is owning property? What does that mean to you? And I know some of you have found the chat feature, so go ahead and feel free to respond to that question for real. What do you see ownership as? people have tried to define what ownership of real property is for a very long time. Property ownership's been around for as long as humans have, and it ranges from tribal territories to basic ancient civilizations like the Greeks and the Romans to the Middle Ages and to now. And so we have lots of different aspects that go into it. What we see now as we look into it is going to be defining property isn't just a single concept like most people try to make. Legal possession is definitely a great way to start that conversation off, Jimmy. And what we have found out by trying to define ownership is that, it comes down to, not just possessing it, but being able to say you can't come on it. And maybe it's even more than that. Maybe it's my right to have it without any kind of encumbrances from people around me, and so it really becomes a complex thing that you start defining and looking at of, if I say I own it, well, what am I trying to say there? Security is another great one. I have a right to my land and to feel safe on my land, to protect my land if I need to. So, what that has led scholars to do is kind of take a nod from philosophy and David Hume talking about the bundle theory of understanding objects, where an object really isn't definable as a thing. An object is all of its parts brought together. And so let's talk about those parts and see where they come from. So what they've come up with is, like we've been talking about, this bundle of rights that is property ownership. This bundle theory is actually pretty recent. As we talked about, ownership of property has been around for as long as humans have in some form or another, but the bundle theory specifically is only about as old as the 1900s. And what we see here is all the things that you guys mentioned in the chat. You have possession, you have control, you have exclusion, enjoyment, the right of disposition, the right to say you can have a piece of my land. All these things play into it. This is not all the rights by any means, but these are a lot of the things we talk about when we talk about owning land. One of the major parts of the bundle theory is that it says, instead of trying to define all the different parts of every type of ownership, what if we just say these are the implied rights of ownership as a bundle, and let's really understand what those individual sticks are, and then we can take a stick out if we need to. We can remove it and only grant, or convey a part of the bundle or the whole bundle. And so all these rights play into what people think of as owning their real property, owning their land. I get more into detail on this in my blog, which I think Lindsay pointed you guys to earlier. So if you really want to dig into this a little bit more, you can go to the blog. And if you want to dig into it really detailed, you can just call me up and we'll chat. I like talking about property. But for the sake of time, I'm just going to kind of jump through these. Let's see here. So once we've defined our bundle of rights, the next big question we have to talk about is, okay, now I have these rights, now what? How long do I have it for? Historically, you didn't have people owning land perpetually forever. You usually had a lord or a king or a sovereign that really owned the land forever. And all of our ownership as the vassals or as the common people was really at their mercy, at their leisure, at their enjoyment. And so, what people had to do back in the day was, we're going to go strictly back to the Middle Ages here on property theory, because that's really where our understanding of modern law kind of starts its common understanding of terminology and modern legal understanding. And what they would have to do is pledge an oath of fealty to that lord in order to get land from the lord. And that was basically a pledge of saying, if anything happens to our general land altogether, I'll come help you protect it. And if you need me to do something or produce something on my land that benefits the kingdom, I'll come do that. But everything I do, even though I own it and benefit from it with my family, is for the benefit of the king and the kingdom, or the Lord and his kingdom. And so what that meant was, great, I've owned it, I've lived on it with my people, my family, but when I die, what happens? It's not technically mine. I've had to pledge fealty, and my family may not have made the same pledge to the king. Well, the lord or the king had the option then to either come back and demand a new pledge of fealty, or they could come back and say, I need it back. I'm going to give it to somebody else because this person pledged themselves to me, and frankly, they did something great for me before, and now they need it. And you don't have any rights to it beyond, me liking you. So I'm taking it back and giving it to somebody else. So this idea of perpetual ownership really resided in them with the Pledge of Fealty. And so today, we've kind of taken that idea of pledging fealty as an understanding of heritability. If I'm going to be able to convey my property to my heirs, that's going to be, I own it perpetually in fee. And what we say then is the most full, complete package. You got the whole bundle and you have it perpetually forever. We call that in fee simple, because you have the whole bundle. Very simply put, you have it all, and then you have it in fee, so you can give it to whoever you want. You can let your heirs take it when you die. You can disperse it to whoever you want, whenever you want. It's completely yours, the whole package there. And so, very briefly, that's kind of where we come from on the bundle of rights of what is ownership, and then immediately after that, the time for owning it. Can we own it perpetually, and how does that work, and what's the history of that? So moving on to the actual part of why we're here, how do we apply all that information to an actual deed? What we have here, guys, is a whole lot of information on the slide, and I'm just going to cover a few high points here. You're welcome to read through it if you want, but we're going to apply this to an actual example I have just after this, so just bear with me. The major parts of a deed I'm going to point out to you real quick on this list are marital statuses are required by law. It's not something that I just do to make people feel uncomfortable about their statuses or to make things difficult on them. A lot of people, they want to be like, oh, you don't have to put your marriage status. I'm from blah, 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 and they didn't make me do that then. So, well, I have to, by law, declare your status. And it's not because I'm trying to shame you or be difficult with you. It's because our law protects spouses. If it's your primary home, your homestead, as we call it, then your spouse has a right not to have their homestead sold out from under them without their knowledge, without them getting a piece of it, or without their ability to sign off on the deal saying they agree to it. And so that is a big part of it, that we have to have the marriage status on our deeds. And so that has defaulted to, we put it on all of our deeds because the probate courts typically want to know. Even if I put on there, this is not the homestead, they still want to know, well, are they married? Because we want to know the status of everybody right here. Let's make it of record so that if anything were to happen in the future, we've at least identified for record whether they were married or not married, so we can deal with that then. Another fun little part of this is that you'll notice consideration is not required by Alabama law, and it's not even required to be written on the deed. The reason we do that is just old habits die hard. You always see that consideration clause at the top, like for $1, for $5, for $10, whatever it happens to be. That used to be when they were trying to hide the true value of what the property was sold for. So they just put a really basic consideration on the deed and say, oh, good enough. That has changed because of our tax rules. The state found out that it was very hard to figure out how to tax people when they were hiding the value of their real estate. And so what we find now is that consideration for the property, if it's given, has to be shown. If consideration is not given, then you have to show the taxable value, the appraised value according to the tax assessor. You also have to show addresses for people because they have to be able to contact these people and let them be contacted by the state. And so we have to identify not only the person, their marriage status, the value of the property, whether it was actually given or not. We have to give an appraised value. And we have to give, like I said, the addresses of those people to be contacted if needed. And again, most of that has nothing to do with the conveyance of property. It's a tax issue. A fun thing to talk about with deeds and specifically with property is legal descriptions and I don't know that we're gonna have time for that today, but if you guys have questions about them, I'll happily go into it with you. The two major types of legal descriptions are lot and block and meets and bounds. If you have meets and bounds, I'm probably gonna tell you to go get a survey, because meets and bounds can get messy. If you have lot and block, we're gonna count our blessings and be excited about it, because that's typically a lot easier. It deals with the plat that's been recorded by the state or by the with the city. And so we're just gonna jump right past all that right now. Addendum clauses are what most people want to know about on the deed, and they don't sometimes know enough to know that, but that's what they need to know. That's where we talk about what's your type of ownership with the people around you. Are you owning it by yourself in fee simple absolute, just you and everything's yours? Or are we owning it with somebody else and they have a 50-50 ownership, like joint tenants? Are we talking about survivorship, where they have joint tenants with rights of survivorship? Most of the time, especially in residential, right, folks, my practice, what we see is that it's going to be joint rights of survivorship being given out, where if one of you passes away, I don't have to go probate your estate in order to make it yours. That right of survivorship says upon death, it automatically goes to that new person because they're the surviving person on the deed. And that's 90% of the time what we do for people. We do not want to create, and this is my informal, unofficial opinion, a bunch of estate issues in a deed. You don't typically want to put your children in your deed because you're like, oh, rights of survivorship, I should just put everyone on there that's going to get the property. No. Talk to an estate attorney, that'll tell you why that's bad. There's a lot of tax implications there. There's frankly a lot of control issues there, where we want you to be able to control your property and not have to consult your kids about what you're going to do with it. So if you have more questions about that, definitely contact us outside. And then the last thing that I want to point out to you guys is that a lot of times I get people asking me for deeds, and they'll say, when can I come in? So-and-so is going to give me a deed. I'm like, well, you don't have to come in. You're receiving the property. If you're receiving property from somebody, you don't sign anything. It's just the grantor that signs it, the person giving the property to you. And so that's like a gift from Santa at Christmas. You don't have to unwrap anything. It's just given to you. It's just there. And so what we typically do is all of the grantor come in, sign the deed. I'll go file it in probate, and then I'll mail it to the grantee so that they have a record of it. But honestly, they don't have to do anything. It's just there. So let me jump in. I know I'm moving fast, but I try and only talk for about 15 minutes so we can have questions. Of course, we got to have the obligatory bear pictures because he's awesome. So now let's apply a few of those sections we just talked about. I know this is very small here. Lindsay has the big blown up version of this. She can share with you guys in the chat. If you do click that, just be sure if you're on a phone that you don't click it till after we're done. If you're on a computer, you can do that because you can have two windows open at once. On a phone, you can't. So, if you click it, you might leave the whole class. So what we're going to see here is I've kind of vomited a rainbow onto a sample of a deed. And we're just going to run through real quick and apply some of the major points that we've talked about so far. So at the top there, you're going to see that we've identified the attorney, and that this is a big deal in Alabama. Not anyone can draft a deed. This is a legal document. We have to have lawyers draft a deed. That's why you almost always have lawyers in title companies in Alabama, because technically we are the ones that have to draft these documents. Just because you know what they mean and what they are doesn't mean you can just draft one for a friend. We have to say who drafted it for record. The second thing in green there you're going to see is the opening, know all men by these presents. That's a real fancy way of saying this is intended for public consumption. We want everyone to know this. This isn't a secret. We want this to be public. We encourage everyone to know about it because part of ownership is letting other people know you own it. If no one knows you own it, what good is your ownership? Someone else might try and claim what you own. So this is a public document. In light blue there, you're going to see that we have identified the grantors. And In fact, right above the light blue part, it's not highlighted, but that's the consideration part that we put in there now. And that's real value or real appraised value from the tax assessor that we put there now. And so again, that's not because I have to, it's because the taxes want to know what to tax you at. There's a transfer tax when you file in probate, and you have to pay it. So again, light blue, you're going to see the grantors being identified there. Remember, we have to have the marriage status and we have to have the address. Right after that, you're going to have the granting clause. The granting clause is important because this is going to set up the language for what kind of conveyance we're making here. Are we making a conveyance with a warranty where we're guaranteeing things? Are we just kind of quit claiming it? We're just saying, you know, if I have it, you can have it now. This is just the setup to that. This is saying I am giving you something. Now we can get into a lot of detail about it, but I don't want to go there right now. This is just, think of this as the granting clause. It says the grantor is giving something to the grantee. The next thing down, that dark green, you're going to see that we've identified the grantee now. There's their address, there's their marital status, and we've had to introduce them as the grantees. Immediately after that, you're going to see a mini, what I call addendum clause. That is actually down a little bit lower in detail, but right here, we just kind of mimic it in short. This particular deed is the one we use most often. It's joint tenants with rights of survivorship. So it introduces their ownership or their granting or conveyance of property in that way. Then in yellow there, you're going to see that term we talked about earlier, in fee simple. Again, you all know now what that means. That means that you have it perpetually. You can give it to your heirs. It's yours in whole. You have the whole bundle for as long as you have it. And then in light green, you're going to see that we have to identify the property being sold by address. Again, this isn't because of there's a legal reason for it. This is because taxes. The tax assessor has a right to require this, and they have. And so we have to give that now. What is the property address being sold? This is different than the legal description. You know, your property addresses were never intended to properly identify property. Property addresses, is a side note just for fun. Property addresses were mostly created for 911 services in the post office, so that they could have quick references to where to go. So when you're identifying property for us, it's really important that from a legal perspective, we focus on the legal description. Your property address, while important, isn't as important as that legal description. Which brings me into the legal. Your legal is a geographical description of your land in a very specific, exact way. That's why it's so important. Your lot and block is just as descriptive as your meets and bounds. The only difference is it references a document previously filed that previously measures a lot of lots all together on a plat. So it just says, hey, go to that. That's where the drawing is. That's where all the details are. Whereas a meets and bounds is very like, you know, go 10 yards to a tree, take a right, go 100 paces to a river, you know, then take another right and follow 50 chains until you hit a stump. You know, they're not usually that ridiculous, but they can be. The next thing you're going to see on that deed in purple is, I call it the source of title section. This is not required. This is something I do to help the chain of title. If you were in my last class, you know the chain of title is very important. This helps link different documents together so that we can trace the chain easier. Moving right along, you're going to see the next one in green. That's the addendum clause. That's the one we're just talking about. So this lays out what type of ownership is being granted to the grantees. How are they taking it together? How are they taking it as an individual? Are we granting all of our bundle of rights, or are we just granting some of them? In yellow, this section is not always there. For a warranty deed, this is always there. For a statutory warranty deed, it's there. For a quitclaim deed, it's not there. What this is the covenant clause. This says that the grantors promise these things are true, and that they guarantee them as the grantors. Now, they can do that because typically they got title insurance last time when they bought it. So they're covered. They were told by a title company that they own it outright. There's no issues, and if issues come up, they just claim it on their title. So now they can feel comfortable granting it to the next person with the same guarantee. And that person should get title. So that title's backing up them. It's a whole different topic from last week, but that's what that is, that section down there. Sometimes when you're looking at a deed from other offices, the habendum and the covenant clause won't be separated. It's just one long paragraph. I try and separate them out because it's easier to understand what you're digesting in the deed. The last thing I'll mention here is that you have a notary block. Notaries have to happen on a deed in Alabama. Otherwise, you have to have witnesses. Without witnesses, it wouldn't be good. And so the notary prevents us from having to have that, and that makes everything good. So there are different notary blocks in Alabama for different types of individuals. That's a side note, just for fun. So make sure you have the right notary block. That's actually a for me thing. You don't have to worry about that. And once again, my bear picture, sorry, it didn't fit on the last screen. He loves going outside and exploring Huntsville, so here he is at the Rocket Center, looking cute. All right, guys, I know I'm kind of long-winded on this one. Real fast, we touched on some of this. Your quitclaim deed is when you convey something that gives no promise of anything. There's no covenant involved in it. It says if I own it, good or bad, now you can have it. Whatever interest I may have, you know have. If I have a piece of a bundle, you know have a piece. If I have a whole bundle, you have a whole bundle. Just whatever it is, it is. It could be nothing. Your warranty deed is the most protection you can get. It's I guarantee that everything I'm giving to you is mine. There's no one else out there that wants it. It's all yours now. If you have any issues, I guarantee it. Statutory warranty deed is a slight step down from the warranty. It basically says that, hey, I guarantee you that I haven't messed it up while I had it. You know, I haven't done anything that would hurt the ownership I am conveying to you. If something happened before me, I'm not worried about that. But I'm telling you, I didn't do anything to mess up my chain. Types of ownership, we're not going to get into that. There's just a lot of different ways. The focus there is rights of survivorship is what most people want on a deed, and we can talk more about that if you want to in just a minute. I'm not going to get into land sale contracts right now because it's a very complex topic, and I've already gone 30 minutes in. If you guys want to ask questions, I will happily answer questions about them. But we're going to save that for another time because it's a long topic. All right, guys, questions. This is the time where you guys can ask your questions in the chat. You can ask to come on stage, so, as we call it, and have a conversation with me about a topic. If you feel like you can't type it all out, all you got to do is let us know in the chat feature what you want to do, and we'll be happy to answer it. Otherwise, I'm just going to sit here and keep rambling until y'all decide to ask me something fun. I know we kind of went fast, but this is the part of the class where I like to actually engage and see if you guys have questions. Sonja asked a question. I hope I said that name right. So she says, what happens when a seller can't find their deed? It's a great question. This is part of that first part of the deed that said this is for public record. Deeds are not good unless they're filed in probate. You know, if you just keep a deed to yourself forever and it never gets filed in probate, it's just a piece of paper. You need to file your deeds in probate, and they need to be drafted by an attorney. And so if you can't find your deed, it's really not a big deal because it's in public record. It's at the probate court. I can go find it, no problem. So while we advise sellers to keep track of them, and because they're important documents, or buyers for that matter, it's not entirely necessary that you keep track of your own deeds because we can always find them in probate. Deeds help us when we're doing title searches because it gives me a legal description, whereas otherwise you're just giving me an address. And sometimes, which I actually just had this 2 weeks ago, the local city that we were working in had mislabeled an address. And so we had crossed our information on what we searched because we had actually searched what address they gave us, but the address that we saw in probate went to a different legal description than what they wanted us to search. And what happened was when they were labeling the street, the developer, they put the wrong numbers on the houses. And so we were looking for one thing, but they wanted us to look for something different. So having the legal description helps us define the legal search when we do a title search better. Helps us make sure we got exactly the right thing. Just as good as your legal is usually your tax ID number, because your tax assessor is going to make sure they're taxing the right property, just like we make sure we search the right one. So tax ID numbers and legals are always preferable when we get contracts. We understand that addresses are just as good as a starting point. Sanjay, I hope that answered your question. All right. You guys are making my life too easy. You got any other questions for me? Let's back up a little bit. I know deeds are a pretty basic concept. You know, you don't really think much about them. They're something that everyone understands on a basic level. You have to own it, and you have to file it in probate, and you need a deed to do that. But you know, this is a great time for you guys to really dig in. And if you had clients ask questions, I mean, if you guys want to talk homestead, we can talk homestead. If you guys want to talk land sale contracts, we can talk land sale. This is really just about the round table part of the conversation, where I'm here for the next 30 minutes to answer your questions. Let's leave it here. In fact, I'm going to open a poll up. Where is that poll? There it is. Lindsay got it up. It's an important poll to me. Does Bear have a shot at modeling? Let me know. There's only one answer.
Oh, someone said,
Sorry.
oh, there's one answer. You're right. I just assumed the second one was a no. And I was like, someone said no. Jeffrey, I have a question for you.
Yep.
Okay, on this color-coded document you have here, did you already know John Krasinski's middle initial, or did you Google it?
I had to Google a lot of information on this deed. Easter eggs on this deed that I fit in there because I was bored one day. If I can find them all, I'll be impressed. Let's see, another question from Sanja. Let's see. Is an example of granting partial rights granting an easement? By the way, Jane, my name sounds like a Y. Oh, Sonia. Sorry about that. So an easement is a different type of conveyance that you can do, because an easement isn't really, I guess you could consider it part of a bundle, but it's not going to be, you don't have ownership of it in the same way that we typically think of when you're getting a deed. You just have a right of access is usually what we're doing. So one of the rights in our bundle is the right to access. It's the right to ingress and egress, as we say. So in an easement, what you're typically doing is saying that we all have a mutual need for this little strip, and I'm going to grant you access purely on an ingress egress level. You don't have a right to do anything to it. You have no other rights in the bundle. So yes, Sonia, you're right. That is part of granting of the bundle of ownership, but it's very limited on the granting side. The owner is retaining 99% of the rights of that bundle. Now there are lots of different types of easements you can grant too, because again, the bundle is much more complex than we went over a minute ago. So you can grant all type, and you can have easement agreements that go along with your granting of the easement, that are maintenance agreements. If you have a road, sometimes they'll include boundary agreements so that you understand where they are. Sometimes you'll have agreements in the easement that have something along the lines of, only to be used at certain times or limitations. And so, all those rights of access don't have to be granted carte blanche the whole thing. They can be limited down. You can get pieces of sticks, so to speak. I hope that answered your question. Robin, can you further elaborate on quitclaim deeds? A neighbor obtained a quitclaim deed on common property in a cul-de-sac development with 5 lots. The property includes the road and 20 feet onto the other neighbor's property. What rights do the other neighbors have with regard to the common area? The developer gave this neighbor the quitclaim. All right, that's a very complicated question. A quitclaim deed in this situation is one issue, but what essentially happened was the developer said, I don't want to take the time to do title search and make sure everything's good and make sure everything's perfect. And I don't want to guarantee what I'm giving you because it's been a complicated development process and there's lots of stuff that's already been conveyed. So I'm just going to give you my rights to what's left of this section. Boom, he granted it. And that quitclaim allowed him to do that without really any concern because he didn't guarantee any of it. He just said, if I still have access to these, now it's yours. So in that situation, you know, let's see here, you asked a couple of different areas here. You said, is a 20-foot section onto the other neighbor's property? That will come down to a question of the chain of title. We can do a title search and we'd see, did the developer still have the rights to grant that property when he did? Again, with the quitclaim, he may not have. He may have not cared. He may have just granted it and didn't realize that that was part of something else because he didn't need to check it. So that's a very specific question I would want to dig into. I'd want to look at your title and look at the history of the other pieces of properties around it and figure out what order they were granted in and who had the authority to grant when they granted it. So that would be my take on that. I'm not sure I got all the way into all the details you asked about, but that would be the way I went about it. I'll just follow up on Robin there at the bottom. The neighbor with the quitclaim wants to erect fencing on the property. Again, I think that that wouldn't be a problem, but my advisement when things like this happen is, one, let's do a search. Let's see what's valid in title in the chain, because you don't want to create a marketability issue with your title where you create clouds or you create disputes. It also doesn't create good neighbor relations, and what's the point of having property if your neighbors all don't like you? If it's investment, maybe you don't care. But if you are going to erect a fence, there's lots of different ways to go about that. You can have boundary agreements. You can have a surveyor come out and mark your boundary only. It's cheaper than a regular full survey. You just do a boundary one, and have them show on physical land what the legal deed says, what the legal description says, and that kind of helps people mark it out in their minds when they're walking around. And so again, there's lots of different ways to go about that particular situation, but I would start with the chain. Let's see if they had a right to get what they got. Marie had a follow-up question on easements. Let's see here. Does the easement have to follow the deed if the ownership changes? So there's different ways to grant easements. You can grant easements that go specifically to a person that only stay with that particular owner. You can have easements that run with the land that stay perpetually with the property. So if either one of us as land neighbors were to move or change ownership, that easement would stay, because sometimes it's necessary to have access to a landlocked piece of property, which is another blog I have, that it has an easement giving it access to it. And so you don't want to grant an easement for a person to use it. You want to grant it for the land itself that runs with the land, so that it's not going to be removed later and prevent someone's access to their own property. So the quick answer there, Robin, is, or Marie, sorry, is to say that sometimes. Depends on how the easement's granted. Easements would be a great topic. We could probably spend a whole class on easements and the different types of easements, the different agreements they make, how they're a little different than the full conveyance of a deed like we usually see here, like we're talking about today. And there's also all sorts of topics that easements lead into, as far as landlocked issues, title issues when it comes to ingress, egress. So there's a lot to get into there. All right. 10 people agree that Bear has a modeling career. I'm very excited about that. It's only 45% of you, though, so we can do better. I'll have to find some better pictures to impress you guys later. All right. Interest in an easement class from Destin. I'll definitely look into maybe doing one of those. We have a couple of classes already preset, but I will be happy to.
I believe we have a property rights class. We just haven't chosen a date for it yet.
That's right. So we can definitely squeeze one into there. It's hard to get these classes. I want to do broad subjects. You guys feel free to ask questions, but I don't want to make it so broad that we don't know what questions to ask. So I'm trying to tailor them a little down to specific areas that we can focus on. All right, well, I hope you guys learned about deeds. I know deeds, again, are pretty basic as a concept, but a lot of people don't ever get into what the deed language actually means, what they're doing. I see, Lindsay there shared our blog to deeds and property rights, how they work. It's a more in-depth version of what we just did. It's going to go a little more into the history. It's going to go a little more into the descriptions of how everything works together. So guys, feel free to go check out that blog. Again, if you just don't have questions right now because you're multitasking, like all realtors do, that's fine. Feel free to reach out to us later. We'll be happy to try and help you guys out, and your understanding of deeds and how to talk to your clients with some authority and, confirm with them that you're doing the right thing and that you're going the right direction with everything.
All right. If anybody wants to still click that link to the blog on deeds and property rights, then go ahead now, because I'm about to swap it out for our registration link for the next class, which is on April 6th. So I'm going to give you 5, 4, 3, 2, 1. Boom. Okay, so when you click this, you are signing up to receive a registration link in about 2 weeks. So we're going to hold the actual registration for the class until 2 weeks from the actual date, just to give you guys a better idea of where your schedules are. We know things come up pretty last minute for realtors, so we don't want you to sign up for something a month out and then, something comes up and you can't attend. So if you sign up here, then I will email you a registration link as soon as it is available. And we hope to see you guys all there. It's going to be a good one. We've got a guest speaker with Melissa Butler with North Alabama Mortgage.
Yeah, definitely sign up for that one. Melissa's great. She's gonna, be a lot like me. She's gonna take very complex concepts and kind of bring them down to, conversable topics with you guys. And I know I enjoyed the last class because it allowed me to give a behind the scenes of my title and how we work and what title is. And I think that's great for you guys to know, because when we have delays or we have issues, you get to talk to your client with authority and knowledge about what that means and what that delay could be and how it's going to work and how to assuage any concerns I may have. And so it's equally as important with the lender side. And so I'm excited to hear what she has to say, and you guys can kind of mix and match and see how me and Melissa work together on a regular basis and how our different sides of the coin have to come together.
All I'm interested to see that class too. I want to know what happens from the loan perspective.
We still have another 10 minutes. Just because no one's asking questions, I'm going to let Lindsay talk a little bit about the things we provide for you guys. Lindsay's job is to be the agent liaison. She's here for you, and we are constantly trying to revamp what we can do for you. So I'm going to let her give a quick overview of all that once again. And then if you guys have suggestions on how we can improve, we're always happy to have that conversation.
Thank you. Yes, as Jeffrey said, I am his agent liaison. So if you guys ever have a contract with us, I'm your main point of contact. I put my email in the chat in case any of you don't already have it. And you can reach out to me directly there or via my cell phone, and I can give you answers on where we are with your contract at any point. I kind of work whenever you guys need me. So I don't have set hours, and you can reach out to me in the middle of the night if you want. But, I'd prefer it in the day.
That's a bold offer, Lindsay. Bold.
I'm here for emergencies, and I'll help you guys. But also, I do like to sleep. And so I help do things like this and set up these classes for you guys. I also send out a monthly newsletter which is designed for you guys to take the information and pass it on to your clients. So we kind of pull everything together from a local news basis, and then you guys can sort of take that as if you did it yourself and put it in your own newsletter and provide that to your clients. So we really just try to make things as easy for you guys as possible and help you where we can. Oh, Alicia, thank you. So kind. Also, use my email that's in the chat if you guys have any further suggestions for classes. Like we said, we have a few lined up for the rest of the year, and we're going to do one every month through December. But if you have one that you would definitely like us to do, like the easement one, thank you, Destin, then send me an email or type it in the chat right now, and we'll make a note and do our best to add one in for you guys. Also, the newsletter that I send out monthly, which you guys have all been added to since you signed up for this class, is where we announce these classes. So make sure that you're opening that to see what the class is for the next month in case you didn't catch the previous class where we announce what the next one is.
Awesome. Thank you so much. Another quick disclaimer, guys. This isn't a CE class. This is really just about having a conversation, so you're not forced to stay with me until we finish. I'm just sticking around because we still have people here. So if you have questions, go ahead and shoot them over. If not, you're good to go. We've really enjoyed the ability to be able to reach out to you guys and talk to you about deeds today. Like I said, it's not legal advice. If you have any specific questions, nothing has to do with that. You need to contact me outside of the class so we can have a real in-depth conversation about your situation. Sonia, another great question. What do I wish realtors knew about deeds? Honestly, when it comes to deeds and realtors, there's not a whole lot I wish you guys knew more about. I feel like clients ask a lot of questions about deeds, about the survivorship thing specifically, or about, is a deed important to the closing process, or with the grantees, do I need to sign that? And so some basic questions like that, I feel like it would benefit you guys to know, so that when your clients go, here's a sophisticated question for you, or unsophisticated, you can go, oh, here's my, what I've learned, here's what I know, but you should always go talk to your attorney about it. As I tell you guys, whenever we have these conversations, always feel free to say, you have to go talk to the attorney. Here's my unofficial, substantiated advice, but go talk to the professionals. I'm always happy to talk to your clients about these things. If you want to tell Lindsay, hey, my client needs Jeffrey to talk to these people, that's great. She'll let me know that I need to reach out to them and talk to them directly about their questions. We talk about deeds quite frequently with people because we want to talk about the legal descriptions. We want to talk about making sure they understand how that works. So great question, Sonia, but I don't have a good answer. I just kind of rambled there for a minute. Thanks for hanging out.
I would like to answer this question. It is being recorded, and as long as you signed up today, you will receive a link via email after the class where you can watch the entire thing again.
It's terrifying and great all at the same time.
Yeah, last time when I watched it back is when I found out I looked like a Monet painting. So that was cool.
Because the Wi-Fi wasn't great.
Yeah, man. And I'm hardwired in today. So do I still look like that,
Nope.
or am I clear? Good. You never know, because I always look clear on my end, and then it's only after when you find out.
All right, guys. I'm seeing a bunch of thank yous. Thank you guys for coming out. Thanks for enjoying this 1 hour just round table session with us. We look forward to next time with you guys. Like I said, we'll still be sticking around for a few more minutes. So if you guys got questions, we're still gonna be here to answer them. I dedicate an hour to these, and I want to make sure you guys have your opportunities if you want them. Rosalind, thanks for confirming.
Also, just from my own personal knowledge, if any of you are still here and just want to help me out on a personal note, if over the past year, if you have figured out a way to avoid the glare on the glasses, in a class, let me know. I feel like there's probably some kind of YouTube hack I can look up, but
There's no reason for this slide. I just like this picture of Bear.
is that your favorite one
Of today, I think.
of today?
Yeah.
You gotta have, if you're gonna do these in every class, you gotta have a real big backlog of photos.
Yes, my wife loves taking pictures of my dog.
Yeah.
So she's always dressing him up and posing him because it's like a hobby of hers. So I have lots of pictures of Bear.
He loves the camera.
Stephanie, these handouts today are actually on the website in our blog section. All of today's information came straight from my deeds blog. You can go check it out there. If you want specific handout information, you just have to email Lindsay and she can get you what you need.
Absolutely. And I also just reposted the blog link. So you can click that link and it'll take you directly to the blog page and you can download the handout, the deed example from there.
Perfect. There are 2 deed sections. One's a more in-depth historical view. Again, not as in-depth as it could have been. And then the other one's a breakdown of the actual language in the deed. So, if you guys want to go overkill with it, you can dig in.
Are you just hoping someone calls you and really wants to talk about all the details of deeds?
All the time. Deeds, property, it's life. Well, Lindsay, you got anything else you want to throw out there before we wrap things up?
No, I think I've done all my stuff. I've sent all the handouts, all the links. I think we're good.
All right. Well, again, everybody, I enjoy these, so we're going to keep doing them for a little while. Like Lindsay said, if you signed up today for the class for next time, it's not technically a sign up. It's just a reminder to get an email closer to time so that we can get a more accurate count. We are limited on seats for these classes, so we're going to try and get a closer to next class actual sign up going so that you can come. But we do appreciate you guys coming, so we're going to give you guys the first heads up and a reminder about it so you can sign up as soon as it's available.
His face. He is a model.
This is a young Bear.
Oh yeah, he looks so brown there.
Yep. He was only like 7 or 8 in that picture.
Aw.
All right, let's go ahead and wrap it up. Again, to those who are still here, appreciate you guys. We're going to go ahead and shut down the class. We'll kick you out. Thanks for coming today. If you guys want to do any follow-up with me, you can email Lindsay. You can call the office. You can email me. And best of luck out there, guys. Thank you.